everything you need to know about summary administration in Clark County, Nevada. First of all, what is it? Summary administration is a particular level of probate in Nevada. It's for estates valued between $100,000 and $300,000, meaning when someone passes away and their estate is valued between $100,000 and $300,000, then their heirs will have to go to probate unless there's a particular type of estate plan in place. You'll be in probate court, and the level you'll be in is called summary administration. I want to talk about generally what happens in summary administration, what's the timeline of events, what do you generally have to do in summary administration. So the first thing that you do in summary administration is you petition the court to appoint someone to be the administrator of the estate, the personal representative of the estate. Because when someone dies, technically nobody has authority over that person because they're no longer here. So you have to petition the court to get someone appointed with authority to handle the estate. So that's step one. You petition the court to appoint someone. The timing from when you file the petition and when the hearing takes place varies, and it's going to change after this video, I'm sure, because it changes all the time. Right now, while I'm videoing this, while I'm recording this, the time frame to get a hearing date once you file the petition, the initial petition, is around 5 to 6 weeks. So once that hearing date is set, then the attorney will appear on behalf of the estate at the hearing date, and hopefully the person that the attorney petitioned to get appointed as the administrator is appointed as the administrator of the estate. The next thing that happens is the clerk of the court issues what are called letters of administration. That's also in combination with the court order actually appointing you, if it's you or whoever it is as the administrator. You're going to get a court order appointing the person, and then you're also going to get letters of administration. These letters are the administrator's ticket to start handling the estate. Until they get the letters, banks aren't going to talk to them. You're not going to be able to do anything with the real estate. You can't hire a realtor and sell the property. Basically, nothing can happen until you get these letters. So once you get these letters, then that administrator can start talking to the banks, the financial institutions, the realtor if you're going to sell a property, and do all of the stuff that needs to be done. The next thing that happens generally is the attorney will file a notice of creditors, or notice to creditors rather. This will be published in the newspaper, and this will also be mailed to all the known creditors. So it accounts for known and unknown creditors for the estate. In summary administration, the creditors, once we publish, right, the creditors have 60 days to pop up and say that they have a claim that they need to be paid. They actually have to file into the case in order to get paid. So unless the creditor files into the case, they're not going to get paid. Even if they file into the case, sometimes there's reasons the administrator might decide to reject a claim. They can either accept a creditor claim or reject it. So it depends on the circumstances. This is all happening, and at the same time, the administrator is, like I said, doing what they need to do and talking to the financial institutions, dealing with all of the assets, listing the property for sale if they need to, hiring that agent to do so. And then as we go through the process, there's additional steps. But what I can tell you is in summary administration, you're still looking at likely 6 months to 9 months on average to get through the whole thing from start to finish. So the other thing to keep in mind when you're in any level of probate, if you're an heir, you're not going to get any money, no inheritance until the very end. So it doesn't matter if properties are sold or assets are sold. All of that money is going to go in a trust account that's held for the estate itself, and it's just going to sit there until the end of probate. And then at the end of probate, the judge will order, by court order, say, hey, we need to pay this creditor, the administrator, the attorneys, and then we finally need to give the money to the heirs that they're entitled to based on the will or based on Nevada law. So it's a process to get through probate, and it's still a process to get through summary administration, but it does take less time and cost less money than general probate, which I will also do a video on, so check that out when it comes out. But for now, I think I've given you a good idea of what summary administration is. If you want to talk about how to avoid probate, how to avoid all of this, then I do also estate planning, so you're always free to give my office a call or go to my website and you can book a call with me to discuss. Of course, if you're in the middle of probate or you're going to be in probate, you're also welcome to call my office. We do all kinds of probate here. That's one of my favorite areas of law. So you can book a call directly with me online, or you can call my office to schedule. My name is Sarah Ocampo at Ocampo Wiseman Law.